Hi there, I'm Emma, and for the last kind of 15 years or so, I spend my daily job advising on contracts, reviewing, drafting, negotiating them. So I'm going to kick off today with why it's important to have standard terms and conditions of sale for your businesses, wherever you are on your path to growth at the minute. Then we'll take a look at some of the common clauses found in commercial contracts. I'm going to focus mainly on standard terms and conditions of sale, but later on I'll discuss some of the other template agreements you might like to have to hand in your database, and then I'll finish with some top contract management tips. So, why bother having standard terms and conditions of sale? I'll be honest, it's an investment to have a set of T's and C's which are tailored and bespoke to your businesses, but it can pay dividends in the long run in terms of saving you money. Not all sales merit a set of T's and C's. I don't recall my window cleaner ever furnishing me with a set, or my local co-op store providing me with T's and C's at the checkout. But it's fair to say that when you're selling tech-based products and services, there'll be ways in which you want to manage your customers within your contracts. There'll be matters which you want relieving from liability to your customers in your contracts. And you may want to actually stand out from your competitors with your contracts by giving enhanced promises in terms of extended warranties perhaps, or exceptional service levels. So in short, having a good set of standard T's and C's for the sales of your products and services gives you power and control over your sales. The more you put into your terms and conditions, the more you'll get out of them. So you need to consider the risks that your business will suffer, the topics that are relevant to your business needs, and any historical issues you've had with customers that you might want to consider in the drafting. You really are missing the true value of a standard T's and C's if you just ask a lawyer to pull you a copy off, or worse still, as we've touched upon, you borrow some from a different website. Because your T's and C's have the power to instill confidence in your customers in what you do, but on the flip side, they also have the ability to cause apprehension and doubt. So let's just take a look at a recent example of this. Does anybody remember this from January, where the government offered a no-deal Brexit ferry contract worth £14 million to Seaborne Freight, and it turns out that their T's and C's were copied and pasted from a takeaway delivery website. Tom Watson relished with the chance to tweet that, I believe. And it's common on commercial corporate transactions whereby we're asked to look at a particular target that one of our clients wants to purchase or invest in. You look at the T's and C's or their privacy notices, and they've been downloaded from a website for free, sometimes not populated at all, but certainly not bespoke to the products and services that the target is looking to sell. And it really doesn't enhance the buyer's opinion of the professionalism of the target. So, and just finally, having a set of T's and C's gives you certainty of approach, certainty as to your liabilities should things go wrong, and certainty as to your legal position. So some key provisions within standard contracts. So term is essentially how long do each of the parties want to be bound to this particular contract. When I'm advising clients on contracts, my first thought is how easily can the client get out of it, and also how easily can the other side get out of it. There's no set precedent for how long a contract should be. Relevant factors will include your acceptable churn rates of your customers, what your competitors are up to, obviously, and how quickly you can amortise your investment with that customer, because you don't want to be able to have a customer walk away from you before you've actually managed to recoup your investment in them. Typically, they're drafted in terms of fixed periods of time, fixed period of times with automatic renewals, and evergreen, which is known as where they continue indefinitely unless and until either party serves written notice to terminate. And if you're dealing with consumers, there's an added layer of complexity in that there's plenty of consumer laws and guidance issued with regards to how you can and cannot tie customers in to long-term contracts if they're not acting in the course of a profession or a trade. Termination lies hand in hand with term. So lawyers will often talk about termination for convenience and termination for cause. Termination for convenience is when a party has a right to walk away from the contract without any reason whatsoever. No fault is needed on either party. And it may be that you want to tie in your customers for longer, but it's not actually suitable in the circumstances. So one of my key clients is a student accommodation operator. And to make their contracts work, they really need to be on the premises for about 3 to 5 years to make the figures work. But obviously, their clients own these multi-million-pound assets, don't want the hands tying, want to be able to dispose of that asset, potentially on day one, without the burden of that contract. So the way we just manage that risk is that we add a termination fee in there. So if you do terminate within the first 5 years, you pay us back a healthy percentage of the management fees we would otherwise have got. Termination for cause is where a party has a right, but not necessarily the obligation, just a right to terminate a contract upon a happening of a certain predefined event. These can be quite highly negotiated in contracts for sales of goods and services. Typical reasons to have a termination for cause would be insolvency events, but be mindful as to when that insolvency event triggers. So, for example, you might see that a party can terminate a contract upon a petition for the other party's insolvency, but it's really easy to petition for the other party's insolvency. All you need to do is send a stat dec demand saying you owe me £750 or more, and then you're actually entitled to go to court and petition for someone's insolvency if they don't pay it and it's a legitimate debt. Whereas I draft that, if it was against my client, as a if there's an insolvency order that's been actually granted. Other reasons, other examples of termination for cause clauses would be material breach that hasn't been remedied within a particular time frame given, normally something like 7, 14, 30 working days, depending on the nature of the contract. Persistent breaches often found in contracts where you're worried about the contract being breached in any manner on a regular basis. There's also change of control clauses, which is where you can terminate if the other party changes its ownership, so the ultimate shareholding changes. You can argue that on the basis that you've chosen to work with that particular party. If they get owned by someone that's your competitor or someone that you're not sure about, you want the ability to be able to walk away. Not the obligation, but just the ability to do so. And fraud of the other party is a common reason. In terms of price, it might sound simple, but it can actually be an area of contention. So you need to be clear in your contracts what's in scope, what's included in the price. Common areas for disputes are often taxes, fees and duties, transport costs, carriage, insurance, those kind of things. When it comes to software licensing in particular, they can be quite complex in terms of who's being licensed, how many people are entitled to use it, how many core processors is it going on. It can become very protracted. I'm currently working actually on the wrong side of a claim, unfortunately. Our client has been approached for being under-licensed following an audit by the software licensor to the tune of £12.5 million. So that certainly falls into the category of an argument over the price. Whether you need flexibility during the lifetime of a contract for your pricing depends on your business model. But if you want to be able to review the price during the term of the contract, think about, is it going to be capped at all, index linked at all, and how often are the reviews going to take place. Avoid wishy-washy language around we're entitled to have price reviews once a year. That actually doesn't really mean anything. It's almost kind of an agreement to agree. You need to be very clear up front as to whether you can amend the price unilaterally and what the consequences of that are. So just be careful about your review mechanisms. In terms of liability, this is probably single-handedly the biggest reason why you want to contract on your own standard terms of sale wherever possible. So, technically, you could sell a £1 widget and be exposed to unlimited multi-million pound claims for that sale. It's not linked to the price at law, it's not linked to what it is that you're actually selling. If you do something that causes your customer loss, there's no liability caps that would apply unless you say so in your contracts. So the way to address that risk is you can, in your contracts, you can exclude liability for certain types of losses. Things like I'm not liable to you for loss of profit, indirect or consequential losses, loss of data, loss of revenue, loss of goodwill. Another way to do it though, and quite importantly, is to make sure that overall you're happy with the level of liability you have under each of your customer contracts. And the way you do that is by setting caps. You'll often see it where they're capped by the value of the contract or £1 million, etc. Because ultimately you could sell a piece of software licensing on an annual basis for £5,000, but that is business critical and has the ability to do such damage to your business's operations if it doesn't if it doesn't function properly, to multi-million pound levels. So unless you're happy with the caps and exclusion of liability in your customer contracts, one particular outage, one particular claim has the ability to render you insolvent. So that's all I want to say on caps. In terms of indemnities, these can cause concern for many. Basically, an indemnity is an agreement within a specified happening to pay for the costs and losses associated with that event. So it might say, in the event that you receive a third-party claim in relation to us doing X, we will indemnify you for all of your losses and costs in relation to that claim. I generally back from my clients giving indemnities unless they are really justified, because the party wouldn't necessarily have a claim at law, so they wouldn't have a breach of contract claim, they wouldn't have a negligence claim, for example. So you often find indemnities for third-party IPR claims if you're selling like IP products and services. So you don't necessarily want to say, we own all the intellectual property in this product. So the way you get about it is, because this buyer obviously wants to know, I do have the right to use it though, don't I? So the way you'll get about around that is to have an indemnity in there that basically says, in the event that someone comes knocking on your door claiming that the use of our product, in accordance with the specification and the documentation, breaches their IP, we will indemnify you for those losses. You'll often link it back to the cap on liability. It might be a higher cap in that instance, but you'll also try and limit the damage by saying, if this happens though, we will only pay out if you notify us straight away, if you give us control over the claim and you do not admit liability whatsoever, and we can do that for you. So that's indemnities. The key takeaway from that is, if you see one in your contracts that you're offering, just really review it or get legal advice, because you can often expose yourself to more risk than you need to do so. Warranties and service levels is essentially just the question, what promises are being made about the quality of a product and service, and over what period is those promises being made? So you might see promises with regard to compliance with specification, you might see promises with regard to our service will be available 99.8% of the time over a given month. Buyers will often look for these things, obviously. In terms of the remedies, if you fail to meet these levels, as a seller of goods and services, you want to be able to limit these. So you want to be able to say, okay, we say that this will happen, but actually if we fail, these are the remedies you have. And it might include things like, we'll fix it, we'll respond to it, we will repair it, we'll replace it, we'll offer you service credits. And if you've got a savvy buyer, you might have to negotiate the right for them to be able to walk away if it's a persistent failing. If you want those remedies to be the only remedy that the buyer has, so they can't come and sue you for additional monies, you need to say that in the contract. Otherwise, you'll find yourself, you're paying out monthly service credits to a buyer, and then all of a sudden you get a claim through where they say, actually, I know you've been paying us service credits, but our losses have far exceeded those service credits, and we're now going to sue you for breach of contract. So if they're supposed to be the only remedy available, make sure that that's explicitly clear. Data protection, I don't know if you're aware of the GDPR, it's quite a hot topic. So in terms of this, in this context, the most relevant area is likely to be if you're a services provider who has access or processes the personal data of your customers, which a lot of IT providers do. So data hosting service providers do, a lot of website development services do, even if you're shredding confidential information, if that's your service. So if you, as a data processor, as part of your services, process your customers' personal data on their behalf, then the GDPR says you have to have certain written terms in your, not necessarily in your T's and C's of sale, but that's where you commonly find them, but between you and your customers. This is a part of Article 28 of the GDPR. And I just want to point out at this stage is that you just need to be a bit careful that you're not signing away your life here, because more savvy suppliers and the most savvy customers have used the GDPR as a reason to put forward a piece of paper saying, please sign this, we need to, it's compliant with the GDPR, but they're actually using it as a means to reallocate risk between the parties, to impose more obligations and controls on you, rather than just technically saying what the GDPR needs it to say. IP is quite an important one, particularly with regard to contractors, as we were discussing, because my biggest issue with regard to contractors is who owns the IP and what they're actually doing if you don't have a written contract in place. And if you're debating whether they're an employee or not, you arguably haven't got the written contract in place. So the default position at law on IP and copyright is that you could commission someone to work on your source code, you could commission someone to take photos of your products, you could commission someone to develop your website, and unless the contract says otherwise, that person that's being paid to do those works owns the intellectual property in that work product. You'll have a license to use it. Even if it's not explicit, you'd probably have an implied license to use it, but you might be then restricted from amending it and modifying it. You'll be restricting how you can use it going forward, and you'll be restricted from stopping third parties from equally using it. Not ideal. So it's one of the most common areas in terms of in corporate transactions. When you do digging around in the target's products and services, and you ask questions, who's worked on the software? Who's developed this? Do you have contractors? Can I see all contracts, please, with these people? And you have one-pagers. And they think just because they've documented the fact that they pay them a day rate of £750, that's fine, but it's not. It stops deals being done, it gets incredibly messy. You are looking then at indemnities in the share purchase agreement, or you're looking at then approaching those third parties months, possibly years after they've done the works to say, you know that work you did, it was always intended, wasn't it, that we own the IP. Can you just sign this piece of paper? And it looks like quite a legalistic piece of paper, and they've got you over a barrel if they don't sign it. So it's quite important that when you're contracting with your customers, you're not giving away your crown jewels, you're only licensing to them. And it's quite important that when you're commissioning works to be done, that you have the relevant ownership rights in those works within your contracts, because the law will not say otherwise unless you're very explicit about that. And finally, just in relation to what we would call the boilerplate, so this is the miscellaneous clauses often found in the back of the contracts. Force majeure, if you're a seller, is a very important one. It relieves you from liability if you can't perform the contract for circumstances beyond your reasonable control. So if your premises suffered from a fire or a flood, or one of your suppliers failed on you, it stops you from being liable, only to the extent that you are prevented, obviously. There's new case law on variations. So if you sign a contract that says, we can only amend this contract if it's signed in writing by the parties, that's now likely to be binding. It was often thought that had a bluff effect and you could actually orally change contracts anyway, but this new case law says, no, actually, if you want to vary a contract, you've got to follow the letter of the law in the contract that tells you how to vary contracts. And governing law and jurisdiction is important when you've got any international element to your sales and your purchases. You need to know whose laws govern and where you can bring legal claims. Brexit aside, actually, clients were quite happy to use the UK courts because they're quite quick and efficient. It's wrong to assume that the laws across the EU are the same. I'd say that if you were to bring a dispute under the German system, they're much more customer friendly and likely to exclude your exclusions of liability and not apply them against customers. And if you like to bring something in Italy, it's going to take you forever and a day to get through the court system. So what contracts might you want to have to hand in the future? Well, we've talked about standard terms of sale. They are pretty much essential if you want to manage your risk and your liabilities under a contract. Do you want to have standard terms of purchasing to cover generic purchases? I'd say if money's tight, probably not to bother at this stage. It's nice to have. We often ask for them in corporate transactions. Can you show us your standard T's and C's of purchase? But there's a health warning with them. Whilst they might be good for covering things like stationery purchases, furniture purchases, they won't be fit for purpose if you're outsourcing huge services. They won't be fit for purpose if you're buying in software or big, large-scale IT procurements. So they're not always fit for purpose, so it's not probably one I would suggest a huge investment is required in. An NDA, confidentiality agreement, very important to always be able to provide one of those relatively quickly before you disclose any confidential information under them. We touched upon our IP ownership, so if you're ever appointing anyone that's touching your products, your services, developing anything for you, make sure you have in place appropriate terms to cover the IP ownership in what they're doing. And then if you're at the stage where you're talking to maybe a lot of parties to do some collaborations or partnerships with, you might want a set of heads of terms or a letter of intent. The key to that really is just to make sure you're crystal clear what parts of the letter of intent are binding. That'll generally be things like the exclusivity, the lock-in periods for discussions, confidentiality is an absolute must. If you talk anything about how IP that's developed at these early stages is how that's to be owned, that should be binding, and governing law clause. But the vast majority where you're just talking about, yeah, we've got this great idea, we think we can do X, Y and Z, and if that happens, we'll split the fees in this manner and the revenue here. That'll all be just your mere current intentions, and that'll be non-binding. Just think through every single paragraph. Do I want that to be binding if all things go sour? Do I not? And then finally, just some top tips for contract management. It's all very well and good having a perfectly drafted set of terms and conditions of sale, but you do need to incorporate them into your contracts before the contract is formed. So it needs to form part of the offer that's being accepted by your customer. So if they're on the back of your sales invoices and that's the first time that your customer's ever seen them or heard of them or been referred to them, that won't suffice because that's post-contractual. No harm in having them on there, but it won't get you home and dry in a court of law if that's all you're relying on. You should set, document and enforce internal authorities for sign-off. So commonly when companies are ramping up, they don't really think about this, but you need to think about the people signing your contracts on your behalf got their eye on risk management. Is it appropriate for your sales guys who are earning commission to be signing off on contracts and amendments to contracts? You should set, document and enforce internal authorities for key amendments to your default position. So who should be able to say that, okay, we accept liability for loss of profit? Who should be able to increase the cap on your liability from the contract price to £1 million? Who should be able to sign off that you're going to indemnify the buyer if you're late in delivering? Employees should know who has these authorities and what they are delegated to deal with. Execute contracts and chase up on counter signatures. Again, it sounds simple, but I've just worked, 5 years ago, I drafted a very complex patent license for a client. They took it back in-house. As far as they were concerned, they'd agreed all the terms, they'd signed it, they'd sent it to the other side. Then months later, they were thinking, okay, we think we've got a binding agreement, can we have a copy? In that time, there'd been a change of ownership in the counterparty, a change of direction. They disputed there was ever a binding contract in place. It was difficult news to deliver to the client because we actually agreed that there was no binding contract in place. So they then instructed different lawyers, took it to court, and the court agreed that there was no binding contract in place. It was a very costly but simple mistake, and they just simply didn't chase up on it. You should hold all copy contracts in a central library. It's important to know at any one point in time who and how you are bound to. And more so if you're looking for an investment or an exit and they want to see all these contracts, it's nice and easy to have them in one place. In terms of complex or high value contracts, I would complete contract summaries. So this basically makes the negotiator accountable for the end deal because they've got to actually document what these terms mean, the risks to the business. And then if there's a different person that's authorised to sign it, they've got a nice summary as to actually what it is that they're signing. And then diarise price review dates, break dates and renewal dates. I was in-house before I came to Squires 10 years ago, and I lost count of the number of times that I was approached on the basis of, we've just had this invoice. Apparently the contract auto renewed, we don't even use them anymore, and we certainly haven't budgeted for this cost. Can you get me out of it? And it's, well, yeah, in 12 months' time, when there's a notice window again, so if you don't get sued, you know, you're going to have to pay it. It's a really important one, that, in terms of knowing when you can change the prices, when either party can walk away, and what you need to do to continue with the contract. And that is all I really wanted to say about good contracting